for judgment.
In conclusion, this writ petition is found devoid of merit and is accordingly dismissed. The order dated 35/2025 passed in petition number so-and-so by the presiding officer, directing the petitioners and their respective families to vacate the premises by removing the belongings is upheld. The time of 20 days granted by the tribunal to vacate and hand over possession shall stand extended for a period of 20 days from this order. The respondent number 2 shall also be entitled to costs. Yes.
My Lord, may I make a motion for item 5 of hearing list, Your Lordship?
Item 5 of the hearing list.
Yes. It appears that Your Lordship, the registry had committed a mistake because we had already mentioned on 13th of this month to be taken up this matter on after 2 weeks, my Lord. The order dated 13/11/2025 had also reflected this.
Okay.
So this may be taken up after 3 weeks, my Lord, because order was already passed.
Do we have the file?
I had
Item.
given the copy of the order also
A
to the
copy of
bench
the order will
assistant.
do.
To the bench assistant, I had given them.
The copy of the order will do. You had given some copy?
This-
Yes,
this-
that one. Okay. In item number 5, Mr. So-and-so appears for the, you are appearing for the
For the appellant.
appellant. For the appellant has pointed out that by order dated 13/11/2025, this matter was directed to be listed after 3 weeks. Full stop. However, the matter has been shown as a fixed item for today in the hearing list. Full stop. In consonance with the earlier order passed, let this matter be listed after 3 weeks from 13/11/2025.
Much obliged.
Yes.
My Lord, item 9 may be taken up tomorrow.
Item 9.
Yes.
Okay.
Much obliged.
Motion, item 1.
May it please Your Lordship.
Yes.
Today, on behalf of my senior, Mr. Pisil Tangmuya, I seek permission to withdraw the case with liberty to file first. There is some clerical mistake, and we need to annex another relevant document.
Ms. So-and-so, learned counsel appearing for the petitioner, has submitted that there are some inadvertent errors in the writ petition, and therefore the petitioner may be allowed to withdraw this writ petition in its present form with liberty to file afresh. Full stop.
Much obliged.
In the absence of objection on the part of the respondents, the prayer is allowed. Writ petition is closed as not pressed in the present form with liberty to file afresh. Yes.
Much obliged.
Item 2, addition.
Yes. Three to 7 is not served. Where is that order of which? Don't it. Okay. So 3 to 7 is not served, but who was required to comply?
My lord, we have received an amount of 38 lakhs,
Huh?
along with the 15 lakhs, my lord.
Huh?
However, the respondents are required to pay a 6% interest for the delay payment, my lord. So a total amount of rupees 2,21,160 rupees is still left to be paid by the respondent, my lord.
Respondent number? Who sanctions the amount? Chief Secretary, Power and Electricity. The money has to come from Power and Electricity. From whom does it have to come, madam?
We have received it from the Power and Electricity Department, my lord.
Yes, who appears for the respondent number 2? Yes, why not the interest part?
My lord, we have explained in para 7 of our affidavit, my lord. My lord, we have explained in para 7, which is at page 5 of our show cause affidavit. The total sum payable was credited on 3/4/2025. And the order directs the payment to be made within a period of 4 months from receipt
4
of
months
a
from?
4 months from receipt
13,
of
12.
certified, yes, my lord. 4 months expired on 19/4/2024. And the full payment was made to the account of the petitioner on 3/4/2025.
So there was some time gap.
It's not, my lord, it's per annum, so the department has construed that if it's within a year, then interest will not lie.
I think you can advise the department better. We don't want them facing trouble here. The orders is clear. The order is clear that in case the payment is not made within the time given, it will carry an interest of 6% per annum till the amount is paid. So I think you should advise your department what to do.
To that effect, my lord, I would like to clarify that the, excuse me, the order dated 13/12/2023 in WPC 80 of 2023 was received by the respondents on 19/12/2023. So 4 months from the 19/12/2023 ended on the 19/4/2024.
Yes.
So the amount received was on 8/4/2025. I said 8/4/2025. So there was a delay payment of 355 days. It may not be 1 year, but still it's 355 days of delayed payment
No.
from
If
the
the-
last date of the ending of the, yes.
You are taking on a very wrong premise. Even if there is a delay of 1 month,
My lord.
then also 6% per annum will come up.
Yes,
As
my
per the
lord.
calculation for that 1 month.
Yes, my lord.
It cannot be that they will pay you, they have a time till 1 year. That is not so. It has been submitted at the bar that the petitioner has received the principal amount awarded by this court, and the only portion that remains to be complied with is the directions for payment of interest on the compensation if the same is not paid within a period of 4 months from the date of receipt of a certified copy of this order. Full stop. The respondents in their affidavit have stated that the order of this court was received on 19/12/2023 and the period of 4 months lapsed on 19/4/2025. Full stop. According to the affidavit, the full payment was made to the account of the petitioner on 3/4/2025, which is disputed by the counsel for the petitioner by stating that it was received on 8/4/2025. Full stop. Be that as it may, it is apparent that the payment of the compensation awarded by this court was made after 4 months of receipt of the copy of the order, full stop. Therefore, the respondents remain liable to pay the petitioner the awarded interest of 6% per annum up to 3rd of April 2025. Full stop. Although the respondent number 2 has tendered his apologies for the delay in payment, comma, fact remains that the payment was delayed, and as per the orders of this court, the petitioner is entitled to the interest directed. Full stop. List this matter again. In the 3rd week of January 2026, to enable the respondents to submit full compliance report of the orders complained to have been violated.
Oblige.
Item 3.
Lordship, regarding this item 3 to 8,
Huh?
they are all connected matters, my lord. They are petitions challenging the validity of the second FIR in Mahindra case. my lord. Regarding these cases, my lord, if I am now being led by senior counsel from Delhi, my lord. So if they may kindly be posted for 1st of December, lordship, on which date the senior counsel is likely to come.
You are appearing for the respondent number?
For the respondent 1, 2.
For 2. Have you filed your counter?
Counter, my lord, that my lord also, I'd like to file, my lord, in the
No,
meantime.
then unless you file the counter, he comes up with a reply to the counter, then what is the meaning of fixing it for the 1st of December again for appearance of the counsel leading from Delhi? Either you give up the counter affidavit
In
part,
the meantime, my lord,
we'll allow him to appear.
yes, in the meantime, I'll be filing my counter, my lord.
Okay. That'll do.
Item 10, 11 and 12.
Yes,
No, he's-
10, 11, 12 also. They are all similar
From,
matter, my lord. They are
from
connected.
item number, kindly be clear.
10,
Item
11,
number
12
3 to item number
Item
8.
3 to 8 and 10, 11 and 12 also.
12. Okay.
They are all connected matters.
3 to 8 and 10, 11, 12. Mr. A.R. Malhotra and Mr. Swenso appears for the petitioners in these criminal petitions. Full stop. Mr. Swenso, learned counsel, appearing for the respondent number 2, prays that the matter may be listed on the 1st of December 2025 to enable the leading counsel, comma, who appears from Delhi to lead the case, full stop. The learned counsel for the respondent number 2 has also assured the court that in the meantime, the affidavit in opposition will be filed, full stop. The learned counsel for the petitioners do not object to the prayer made by the learned counsel for the respondent number 2, full stop. Accordingly, list this matter on the 1st of December 2025, by which date the counter affidavit on respondent number 2 shall be brought on record, full stop. Petitioners would be at liberty to file their reply, if any, to the same.
Obliged, Your Lord. 1st of December.
Item 9.
Item 9. Yes.
My lord,
AD card in respect of the respondent number 4 has returned unserved with no remarks. So, my lord, fresh step
Respondent number 4.
4, yes.
Who is
No-
4?
He's the DO, my lord. Defense Estate Officer.
Defense Estate Officer.
My lord.
It is for the Ministry of?
In fact, my lord, why notice was issued only in respect of the respondent number 4, my lord.
What is the order?
Order is from page number 14.
Page
Order
21.
1808-2025, my lord.
Effective portion is at page 21.
My lord. From paragraph 13, if I may read. Accordingly, it is provided that the respondent authority shall make a verification regarding the issuance of the LSC to the petitioners, and in the event of those found to be genuine, then the respondent authority shall pass a reasoned order regarding their entitlement of rental compensation for occupation of their land by the security forces since the date of issuance of the LSC till formal acquisition of their lands. After detailed assessment, specially by the respondent number 7, Deputy Commissioner, District Collector, Aizawl District, before passing a reasoned order, the respondent authority shall afford an opportunity of being heard to the petitioners. Now, my lord, pursuant to this order, if your lordship could kindly come to page number 31.
I just want to find out why only respondent number 4.
Because, my lord, the respondent number 7 had made this verification, and they have verified at page number 35 that the land passes of the instant petitioners are genuine, my lord.
Then?
And
Then-
thereafter, at page number 31, my lord, the respondent number 7, the Deputy Commissioner has also made a rental assessment, which is total amount 70 lakhs 57,701,706, my lord. So far as the respondent number 7 is concerned, my lord, he has done what has been directed of him. So what remains is for the respondent number 4.
Let us again see respondent number 4. What have you written? What is the address given?
My lord, address given is...
Page number 5.
yes, my lord.
Serial number 4. What do you say about the address? Guwahati Circle, Post Office, Silpukri.
My lord.
Come to page 31.
My lord.
What is the address at the top?
This is different.
Then come to page 35.
My lord.
Copy to Defense Assistant,
Yes.
serial number 2. What is the address?
So, my lord,
He
if
will
I-
never get it.
my lord, if I may be allowed to...
So file the
take-
corrected address,
Yes, and fresh step may be...
and you have to take fresh
My
steps. And you have also to show that, okay. Yes, heard Mr. So-and-so on a council appearing for the petitioner, full stop. The office note reflects that the steps, that the notice sent to respondent number 4 has returned unserved, full stop. The learned counsel for the petitioner has submitted that there is a inadvertent mistake in the address of the respondent number 4 as reflected in the contempt petition, and the correct address is available at page 31 of the contempt petition as well as at page 35 of the contempt petition. Full stop. He accordingly prays that he may be allowed to file an amended cause title to the in the contempt petition to furnish the correct address of the respondent number 4. Prayer made is allowed. Petitioner would file an amended cause title with the correct address of the respondent number 4, full stop, registry to make necessary amendments in the CIS system accordingly, full stop. Petitioner, after furnishing of the amended cost title within a period of 3 working days from today, comma, the petitioner shall take steps on the correct address of the respondent number 4 within a period of 1 week thereafter. Full stop. List this matter again after 4 weeks on a date to be fixed by the registry with service report.
I'm deeply obliged.
Yes.
Orders, item 13.
13.
My lord, service upon respondent number 2 is still awaited. If some time can be given. I'm sorry, in the petition.
My lord, last court date, the states are instructed to to serve notice to Ministry of Home Affairs since the respondent number 2 is
From Myanmar.
from Myanmar.
So did you find out the process, how it is done?
My lord, I have just given it to the department. I have not found it out, my lord, yet. This is the first time we have this kind of case.
Let us see. Where will we have it? This is an appeal against respondent, and this is respondent number 2 we are trying to trace out.
Yes, my lord.
And he has vanished. So was he held guilty? It was an acquittal.
Yes.
Discharge, my lord.
It was an
Discharge.
discharge. But the respondent number 1 is appearing. Is the respondent number 1 appearing? Anybody for the
I'm
respondent number
appearing
1?
for respondent number 1 and 3, my lord.
1 and 3. There's a mode of service is there. Just a minute. Official capacity, Naval Corporation. I am having a hunch that it is possible because in Assam you must have heard there was a death of a super star who was a singer.
Yes,
The death
yes.
occurred in Singapore.
Yes.
And the police are coordinating to have all the notices and everything served upon the suspects in Singapore through the embassy.
Yes.
So there is a procedure which can be followed. We have to find out what is it. Hmm. 18. Can it proceed against the respondent number 1 and 3?
My lord, I think we can proceed.
We can proceed also.
Huh?
We can proceed now.
Then he, the Myanmarese person, he goes scot-free. In
Yes,
his
my lord.
absence, we cannot proceed against him. Otherwise, the other two are appealing. Where is the judgment? What was the allegation?
My lord, the judgment of the learned trial court is right next to the index.
Okay, so prima facie case not established.
If your lordship can give us some time, I'll try to find it out what the department has taken steps, and I'll also try to find out how to serve notice to the
See,
respondent.
I've given you the example, this
Yes.
thing is done, it is not as if it is not done. I think you need a treaty, some sort of a treaty has to be there, and then the High Commission helps
Okay.
for service of notice. But then here it is also held that Foreigners Act would not apply. Have you seen that part? This page 17, no, page 16. Nothing in the record indicated she is a Myanmar nationalist. But how can Foreigners Act Section 14 be dealt with by the NDPS court? Foreigners Act. Where is the Foreigners Act? You have the Foreigners Act there? No, please. You need a foreigners tribunal for this, don't you? Goodness. Okay. The learned APP appearing in the matter has submitted that she is awaiting instructions regarding the mode of service to be adopted for serving notice on the respondent number 2. The prayer is not objected to by the Learned Council appearing for the respondent number 1 and 3. Full stop. Accordingly, list this matter after 2 weeks
All right.
on a date to be fixed by the registry. The respondent number 1 and 3 have already filed their affidavit in the matter. Full stop. Yes.
Obliged.
Item 14.
May I please, Your Lordship?
Yes.
Yes, Lordship, here in this matter, paper book has already been prepared, Lordship, and I have also received the paper book, Lordship. The matter may be fixed for hearing, Lordship, final hearing, Lordship.
Yes.
Yes, Your Lordship, we have received the paper book.
You have,
Yes.
the learned counsel for the parties have submitted that they have received copies of the paper book and it is also found on record, full stop. Accordingly, list this matter when. When do you want it?
Lordship, on 12th December.
It is just one day
Yes.
prior to the vacations.
Yes. Or 10th, Lordship.
10.
We'll have it immediately we'll have it on the third week of January,
Yes. Okay.
immediately on the reopening.
Lordship, the accused is not in bail, Lordship.
Huh?
That's why I am.
Ah.
He is not on bail.
You could have started off today. If you are in a hurry, we can start off today, there is no problem.
No, subject to Lordship convenient. That's not date, Lordship.
Okay, we'll have it on the third week of January, yes. List this matter again on third week of January for hearing.
Item 15.
Any date, Lordship.
Huh?
Any date, Lordship, third week of January.
Third week of January, any date? Thursday. Twentieth of January, 2025.
Lordship.
20
Earlier.
January 2025. Yes.
Item 15.
May I please, Lordship?
Yes, sir.
My Lord, in this case, service in respect of each and every opposite party respondent is complete. And this is an application for condonation of delay of 31 days in filing connected appeal. Due to necessity of correspondence from Aizawl to Silchar to Guwahati, which is regional office.
Yes.
So even till that, the objection is not filed by the respondents. So,
Yes, Lordship, if I would like to submit that we have received the notice and we will not be filing our affidavit in opposition on the condition that 50% of the awarded amount is deposited to the registry of this honorable court. That is 37,56,770.
Where is that order? Order under challenge? You have not annexed the order
my Lord,
which you are assailing.
main appeal. Main appeal number.
How do you find out when
16,
when did you get a copy of the order? When was the certified copy
My Lord,
applied? Nothing.
certified copy is annexed.
Where?
Annex 0.
Eh?
Annex 01, page number 11.
Page
This
number?
is true copy. And certified true copy is in the second page, from the second page. This one.
Of the IA?
Index. Next to index, certified true copy is there.
Where?
My Lord, in the IA,
In the IA, what
IA.
page is the certified copy of the order or the uncertified
certified
copy?
true copy of the impugned order is not annexed.
Eh.
In the IA,
Then how do you calculate the delay? Merely on your
but what
statements?
is annexed is correspondence letter from here to Guwahati.
See, if you are saying that this is the day I received the certified copy, this is the day I applied, then how does one calculate the delay if it is not even there in the IA?
Annex 1 in the IA is first correspondence letter, page number 9.
Correspondence does not help. What are you challenging is what we want to know.
Our dated
Which part?
22nd April 2025.
Total compensation. Okay.
75 lakh 13,435.
So which part are you challenging?
My Lord, with regard to loss of dependency, the deceit was a bachelor, and loss of dependency. With regard to loss of dependency, 50% of salary of the deceit has to be deducted. And the second one is with regard to consortium. Claimant respondent number 1 is father of the deceased, and the rest are major sister, nephew, and niece of the deceased. So, except claimant respondent number 1, other claimants are not entitled consortium. Claimant number 1, being a father of the deceased, entitled filial consortium to the tune of rupees
So
40 lakhs.
the claim before the tribunal
Yes,
regarding the nephew, niece and the sisters,
yes,
this had to be contested by
yes. It was contested
you.
by the opposite party respondent, this insurance company.
Could you, did you move that application praying for leave to contest?
Well, since owner of the vehicle or the driver of the vehicle have not contested the case,
So you should have
under
moved an
170
application.
is not there.
So you should have moved an application saying that I will take up all the claims, I will contest all the claims. Was that done?
But actually, no leave under 170 is granted because the owner of the accident offending vehicle or the driver has not contested the claim. So there can be no collusion between the claimant and the opposite parties. So for that reason, leave under 170 is not warranted.
That's it. Okay. Heard Mr. So-and-so and counsel appearing for the applicant. Also heard Mr. So-and-so and counsel appearing for all the respondents. Full stop. The prayer in the interlocutory application is for condonation of 31 days of delay in preferring the connected appeal filed assailing the order dated 22/4/2025 passed by the Motor Accidents Claim Tribunal Aizawl in connection with MSCT case number 20 of 2022. Full stop. The learned counsel for the respondent has submitted that the petition may be taken up on merits. Full stop. We have perused the grounds given in the interlocutory application and observe that they are sufficient to explain the delay of 31 days occurred in filing the connected MSC appeal. Full stop. Accordingly, this interlocutory application is allowed. And the delay of 31 days in filing the connected appeal is condoned, subject to the condition that the applicants shall deposit 50% of the awarded amount with the registry of this court within a period of
4 weeks.
4 weeks from today. Full stop. The opposite parties would be at liberty to pray for
Lordship,
disbursal.
if I may be allowed to add some, and the same deposited amount may be dispersed to the...
That is what I am saying. Once they deposit it, you will be at liberty to make an application to be allowed to withdraw the same.
Okay.
Okay. Yes. So IA stands allowed to the extent indicated above. Full stop. In the MSC April 16 of 2025, you take down, list this matter after 4 weeks. on a date to be fixed by the registry.
Item 16.
Yes. Yes, contempt case.
My lord.
Notice issued.
Yes, my lord. 1 and 2, AD has returned on 13/2/2025. However, they are still unrepresented.
Who
Respondent,
is 1 and 2?
respondent number 1 and 2 is the Chief Secretary and the Secretary of Mizoram, Government of Mizoram Land Revenue, my lord.
1 and 2. Yes. You are appearing for?
I'm appearing for 5 and 6, my lord.
3. No, this is the first time it is coming up.
No, my lord. There was a new incumbent for the post of respondent number 4, which was impleaded. The new incumbent was impleaded, and the steps was taken on 6/11/2025. Notice through Telangana.
How was it implemented? Today the IA is there for orders. What is
IA is from the respondent 5 and 6, my lord.
Yes, for
But-
what?
Striking off or deleting the respondent number 5 and 6, my lord, since
Why?
all the assessment which was done by the Kala has already been deposited by the respondent 5 and 6, my lord.
Then,
My lord, the direction was to respondent number 1 to 3 in the writ petition, my lord. So,
The deduction of 15% cess, my lord, was done by the state government, not by us, my lord.
not by you.
Yes, my lord. In
What
fact,
do you
we
say
had
to that? They have complied with their part.
the respondent number 5 and 6 have already complied, my lord. So the answering respondents should be respondent number 1 to 3, my lord. The direction also passed in WPC 1 of 2024 at
Where
page
is that
number
order?
14 of my petition, my
Where
lord.
is the order? Where is the order?
14.
1, 2, 3 to refund the cess amount deducted. Then why 5 and 6 are appearing in this court? Why were they issued notice at all?
Yes, my lord, I have inadvertently impleaded them as parties in the, while filing the contempt petition.
Yes, take down in the interlocutory application. This interlocutory application has been filed by the applicants, who appear as respondent number 5 and 6 in the contempt petition. Full stop. It is the stand of the applicants that the impugned order, order of which violation has been alleged, had required the respondents number 1, 2 and 3 in the writ petition to refund the cess amount deducted from the compensation amount to be received by the petitioner within a period of 6 weeks from the date of receipt of the certified copy of the order passed in WPC number 66 of 2022.
My
Full
lord,
stop.
1 of 2024.
Sorry?
WPC 1 of 2024.
Oh,
Page
sorry.
10,
You write, of which the community was required to refund the cess amount. Now, where did I write the WPC number? I wrote 66 from 2022, na? You correct it to 1 of 2024. Instead of 66 of 2022, make it 1 of 2024. Full stop. The learned counsel for the applicants have submitted that they had already paid up the total amount awarded by the Kala, and therefore no directions were passed in the writ petition
Yes, my lord.
requiring them to do anything further in the matter. Full stop. The learned counsel appearing for the opposite party in this interlocutory application, petitioner in the contempt petition has submitted that in fact the respondent number 5 and 6 are not required to do anything further in compliance with the orders passed in WPC number 1 of 2024. In view of the submissions made and after perusal of the order passed in WPC number 1 of 2024, this court finds that the respondent number 5 and 6 have not committed any willful disobedience or violation of the orders passed by the court. Accordingly, the two respondents, namely the respondent number 5 and 6, are discharged from this contempt case. You are appearing for respondent number 3. Who is 3?
Kala, my lord. The competent authority for land acquisition, Saitwal district, my lord.
She also has nothing to do in the matter.
They are the ones who have to comply with
You have
the
to do
matter,
it.
my
Yes, where is your affidavit? The order is for 1, 2 and 3. Where is your affidavit?
That, my lord, we have refunded some of the cess to some of the petitioners in WPC 1 of 2024. That, my lord, however, if I may take your lordship to page 15 of the contempt petition.
Page 15.
Yes, my lord. Table 2.
Yes.
Table 2, 3G of NH 102 package 2 Polrang. And this is a different 3G. The dated is different. So here, however, in this contempt petition, the 3G dated is the same. So I have to get instructions as to, yes, whether the table 1, the cess is already refunded. However, the table 2 is the persons who filed the contempt petition.
In the contempt petition you take down. So 1 and 2, you said there was some impediment of parties?
Yes, respondent number 4, my lord. There was a new incumbent to his post. Respondent number 7 is a newly impleaded. Steps was taken on 6/11/2025. However, notice has not returned.
For respondent number 7?
Number 7, newly impleaded, my lord.
So that, my lord, I need to get instructions regarding this.
What about respondent number 1 and 2?
They have not been represented, my lord.
Although they have received?
Yes, AD card was returned on 13/2/2025, my lord.
Are they still holding the posts?
To the best of my knowledge, yes, my lord.
Okay. Take down in the contempt petition. Heard Ms. So-and-so and counsel appearing for the petitioner. Also heard Mr. So-and-so and counsel appearing for the respondent number 5 and 6. And Ms. So-and-so appearing for the respondent number 4.
3.
Respondent number 3, full stop. By the order dated, by the order passed today in IA civil number 205 of 2025, the respondent number 5 and 6 have been discharged of their liability in this contempt petition, full stop. Ms. So-and-so appearing for the respondent number 3 has submitted that she is awaiting instructions from the respondent number 3 regarding the payment regarding the refund of the cess as reflected in table 2 of paragraph 4 of the orders passed in WPC 1 of 2024, full stop. She prays for an accommodation of 2 weeks to have her instructions, full stop. Prayer is allowed. The respondent number 3 would be at liberty to shall file the affidavit in response to this contempt petition within a period of 2 weeks, full stop. It is noticed that the AD cards with regard to service of notice on the respondent number 1 and 2 have returned back after service, full stop, yet there is no appearance on their behalf today, full stop. The respondent number 1 and 2 are given an opportunity to ensure appearance on their behalf on the next date of listing, failing which appropriate orders would be passed by this court, full stop. List this matter again in the third week of January 2026, along with the affidavit proposed to be filed by the respondent number 3, and also to enable respondent number 1 and 2 to enter their appearance, full stop. Service report on the respondent number 7 shall also be verified and placed before this court by the registry.
Much obliged.
Yes.
Item 17.
May I please, Your Lordship?
Yes.
My Lord, this I is for seeking treatment of the present incumbents of 2 officials. The present Secretary of Land Revenue and Settlement Department of the State Government, as well as the Chief Engineer of BRTF. And my Lord, although I have not made a specific statement, my Lord, the other day, in other case, this court had expressed the opinion that we have to first serve the copy to the official concerned. And in this present case, my Lord, I'm going through the brief, and I find, I just came to realize that on 29/11/2024, we have served copy of the judgment to the Secretary of Land Revenue and Settlement Department. And on that day, the respondent number 8, which we seek to implead in this IA, already hold this post. That means this respondent number 8, which I'm seeking to implead, assume the charge of this post with effect from 9/9/2024. 9/9/2024. And we have served copy of this judgment on 29/11/2024.
Okay.
But as for the Chief Engineer, my Lord, he held the post only with effect from 27/9/2025.
Hold post and service. And respondent number 7, you said he came to the post on
27/9/2025.
27/9/2025. And when did you serve the copy?
The copy was furnished on 21/1/2025.
So I think on respondent number 7, you have to serve a copy again.
Yes, my Lord. So as for the respondent in respect of present incumbent of Revenue Secretary, my Lord, he may be arrayed as respondent number 7 instead of 8. In my IA, I have proposed to array them as 7 and 8 respectively.
No, then...
If Your Lordship may kindly come to page number 5 of my IA.
Yes, I've seen that.
This Sri Vanal Moya, the Secretary of Land Revenue, may be arrayed as respondent number 7 if my application is allowed.
Yes.
As for the other respondent, I'm proposing to implead, my Lord. I'll take necessary steps.
Heard Mr. So-and-so on a council appearing for the applicants. The counsel for the applicant submits that the respondent, the proposed respondent number 8 that is Shri Vanlal Mauya, who holds the post of Secretary Land Revenue and Settlement Department, Government of Mizoram Aizawl, has been holding the post since 9/9/2024, and the copy of the order dated 21/11/2024 was served on 29/11/2024, full stop. He submits that therefore the said proposed respondent number 8 of the respondent number 8 has notice of the orders of this court and has yet failed to ensure complete compliance of the orders, full stop. He submits that in such circumstances it is necessary to implead the said respondent as a party respondent number 7
Yes.
in the contempt petition number
18 of 2025.
18 of 2025, full stop. With regard to the proposed respondent number 7 in the interlocutory application, comma, the learned counsel for the petitioner submits that he has recently joined the office and therefore the petitioner may be allowed the opportunity to serve a copy of the orders passed in WPC number 103 of 2023 on the said respondent to make him aware about the orders passed by this court and also about the pendency of the contempt petition, full stop. Next paragraph, the prayers made by the learned counsel for the applicant is allowed, full stop. The Shri Vanlal Mauya, comma, the Secretary, Land, Revenue and Settlement Department, comma, Government of Mizoram Aizawl, is allowed to be implemented as the respondent number 7 in contempt case number
18
of 2025, full stop. Petitioner shall furnish an amended cost title to the registry within 3 working days from today, and the registry shall carry out the necessary corrections in the CIS system, full stop. Notices of the contempt case, CIS system, full stop. Then you write, the petitioner would be at liberty to file a fresh interlocutory application for implement of the earlier proposed respondent number 7 after service of notice upon him as proposed by the learned counsel for the petitioner, full stop. Interlocutory application accordingly disposed of. We are closing this interlocutory application. Once you serve the copy,
Yes, my
it
lord.
doesn't comply, you come
Yes, my
back.
lord.
Okay, in the contempt case, you write down by the order passed today in interlocutory application number 216 of 2025, comma, Shri so-and-so has been allowed to be implemented as respondent number 7 in this contempt petition, and the petitioner has been directed to furnish a copy of the amended cost title to the registry within 3 working days, full stop. Upon such submission of the amended cost title, comma, let notices be issued to the newly implemented respondent number 7, full stop. Steps to be taken by the petitioner for service of notice within 1 week thereafter, full stop. List this matter again after 4 weeks on a date to be fixed by the registry, along with service report on the respondents.
Deeply obliged.
Yes.
Hearing item 18.
Yes, sir.
Yes. My lord, this criminal appeal is against the conviction of the appellant under section 304 IPC, culpable homicide part 1, my lord. 304 part 1. And the sentence for rigorous imprisonment for 7 years. My lord, the but he did not die instantly. And after some time, while he was brought to the hospital, he succumbed to his injury, my lord. So unfortunately, he died. So I was initially booked under Section 302 murder, my lord, IPC. Charge was also framed under Section 302 IPC, but I was convicted under Section 304 Part 1. So let me start with the FIR, my lord. Page 2 is the FIR.
Now, you admit that you were engaged in the scuffle? You admit that you have raised your hands?
No, my lord.
That part is also denied?
Denied.
But you deny total involvement? You
Yes,
totally
I
deny
only-
all involvement?
Yes, I merely pushed him because he was doing.
No, so
Yes.
so you admit to the scuffle, you admit to being involved in the incident, but
Yes.
you say that it was the intent to injury or knowledge of that the injury could have caused that is not there. You did not punch him.
Yes, I did not punch him. Only I merely pushed him, my lord. Because he did the action first. So you know that I was doing my self-defense. So my lord, page 2 is the FIR.
Just a minute, I was reading the judgment.
Hmm.
Can we read the judgment first to find out?
Yes, my lord. The impugned judgment is at page 34.
Because no one, even if no one saw you in the scuffle, when you have admitted that there was a scuffle, for a time being we can keep that on hold. We can try to find out what the witnesses have, how the witnesses have been evaluated, to find out whether you hit or not, did not.
Eyewitnesses were there.
So that is what we are trying to
Yes.
find out.
My lord, the relevant portion will be from page 53.
53?
53 of the paper book.
Yes.
May I read from para 20, my lord?
Page 53?
53 of the paper book.
I am reading your appeal.
Oh, paper book is there, my lord.
My mistake. Yes.
I'll start from para 20, my lord. At the very outset, this court finds it appropriate to consider the various objections raised by the learned defense counsel. His contention that the PW3 did not make the judicial statement voluntarily is found to be unreasonable, as the PW3 had categorically mentioned that she had voluntarily gone before the magistrate for recording of her judicial statement, and more so because the issue was not raised when the PW3 was cross-examination. Regarding the contention that the inquest report was not forwarded to an executive magistrate, it is found that it did not cause prejudice to the accused. The argument of the learned defense counsel that there was procedural lapses by submitting that the accused was arrested on 14/3/2021, whereas the FIR was registered on 15/3/2021, is found to be factually incorrect, as the arrest memo, Exhibit P6, showed that the accused was arrested at 2:30 am on 15/3/2021. His submission that the complainant had contradicted herself by stating that the FIR was written on the police station on the one hand, and that it was written in her house on the other hand, is found to be minor discrepancy, which did not cause prejudice to the accused. Regarding his submission, the judicial statement of PW3 recorded under Section 164 CRPC was not substantive evidence. This court holds that the judicial statement Exhibit P2 was admissible evidence after it read over again and exhibited by her, PW3, when she testified before the court. Moreover, the PW3 was cross-examined on the facts she has stated in her judicial statement by the learned defense counsel. The other grounds of defense raised by the learned counsel are being answered in the following discussions. It is found from the evidence adduced by the witnesses that PW4 went to the house of the victim at around 2 p.m. to 3 p.m. on 14/3/2021 Sunday and invited him to go to Lunglon. It is also found that they had gone to Lunglon by a scooty, drank alcohol at a place near Veti Hospital, Farmway, and had happened to meet the PW8 at Farmway. The PW8 joined them and he drove scooty with the victim and PW sitting behind him. PW8 got down at Puboka Point, and as requested, he purchased a packet of silk cut cigarette from a nearby shop for his two companies. Meanwhile, PW and the victim talked to each other. The accused sat on a step close by watching his phone, and the PW4 moved forward in the driver's seat of the scooty. It was around 6 p.m. by then and about to get dark. The accused shouted at them, asking why they were noisy, and there was a broil. An eyewitness described the scene as if there was an argument between the scooty riders and the accused. The accused fisted the victim and he collapsed on the road surface and remained there motionless. He had also punched the PW on his cheek, who was fleeing the scene. Even though the prosecution had contended that the accused had hit the motionless victim again, it is found unsafe to rely on the contention, as the said eyewitness had retracted from her earlier stand, stating he did not see the accused assaulting the injured. And PW 5, 6 and 7.
So even if you pushed or even if you punched,
yes,
he died because of a brain hemorrhage caused by an injury to the head by a blunt instrument.
Yes.
Now, was it at the behind of the head or at the front of the head? Where was the injury? That hemorrhage, where did it take place?
Injury was, my lord, doctors.
Where is the doctor's?
Doctor's evidence it at page 29.
29?
29.
Yes.
Para 3.
Intracranial hemorrhage. Right occipital area, small laceration in the right parietal area. Skull base was fractured. Hematoma left tempoparietal area. Yes.
The victim was drunk, my lord, in fact.
Huh?
So, and
Where do we
amongst...
find it? Where do we find that the victim was drunk? Who
my
says
lord,
so?
the evidences recorded had revealed that, my lord. My lord, let me take your lordship to page 14. This is the eyewitness, PW number 3. Because PW1 is the wife of the victim who lodged the FIR. PW2 is, the appellant was wrongly cited as one of the witnesses as PW. So he was dropped, the present appellant. So PW3, it will be relevant, my lord. Prior to that, let me come to the confessional statement, the judicial statement recorded, my lord. 87 first.
Page 80?
87. She said that she clearly saw the accused, the convict.
Who is she?
She is the one who was staying nearby the neighboring, at the neighboring house, my lord. Page 87. I'll start from the last question, my lord, please. She said that she saw
She
the
is
hitting.
15 years old.
Yes, my lord.
Is she 15 or 25?
It is written as 15.
But then down below it is written as 25? A little bit of 15-year-old asking a rickshawala to help her, no one else coming up forward. How is she related to the deceased? Is she related? No.
No, my lord.
Okay.
Page 14 is the her evidence. Page 14 says 25 years old.
Okay, we'll take it to be 25 then.
Yes.
Huh?
Yes, my lord.
We'll take it to be 25 years.
Yes.
Okay.
Then after she said in the judicial statement that she saw me hitting the victim, due to which he fell on the road, on the floor. But your lordship, page 14, it is her evidence.
Just a minute. Page 40, 14.
1-4, my lord.
Yes.
My lord, I'll come directly to cross-examination. She said that the victim and his two friends were drunk, and they were riding in one scooty, 3 persons, including the victim. And my lord, para 7 of the cross-examination, page 15 is relevant. Para 7 and 8.
Yes.
She did not see me assaulting the victim, my lord. So she retracted.
The injured, also the injured and his colleagues accusing, assaulting the accused.
Yes. So, my lord, her evidence that what she has stated in judicial confessional statement was also rebutted, my lord, in her cross-examination. And PW4 is the one who was riding in a scooty with the victim, my lord. Page 16 is the evidence, 1-6. PW4. Why I am pointing out this is that, my lord, they are the ones who are considered as eyewitnesses.
Okay.
Because their evidences are relevant. I'll come directly to page 17, my lord.
Now let us see how the story is made out by each of them.
Okay. 16 is the examination in chief. Lord, page 17.
Just
How-
a minute. The
Para
victim
2.
saw me and talked to me saying that I had arrived. He told me he wanted to go to bathroom. I took him away. He bled profusely from the nose after he
Yes.
would have.
This could also be the reason, my lord. While he was instructed not to, there was a cotton piece on his nose to block the blood oozing out. But he removed that cotton piece by himself. Maybe due to loss of blood, we don't know. Because he did not die immediately, my lord. In your lordship cross-examination, para 2 and para 5. Para 5 says that it is a fact that the victim was falling from the scooty and fell on the road when the accused punched me. This pillion rider was punched by the accused, not the victim. This is what he said. The victim was not punched at all.
It is a fact that the victim was falling from the scooty and fell on the road when the accused punched me.
Yes. So it was the pillion rider, this particular PW number 4, who was punched by me, but not the victim, my lord. But due to that reason, it appears that they were drunk. They all were drunk. And he fell from the scooty on the road. And then he hit his head on the road.
Which is the occipital part of the skull? Occipital, if I'm not wrong, is this part, or this part. Which part is the occipital part?
And para 7 also, my lord.
If you are saying that the victim was falling from the scooty and fell on the road when the accused punched me, earlier he said that he came towards us and punched the victim who was on my scooty.
But what he explained clearly is that at cross-examination, para 5 is that it was, yes.
This person, he punches both the men simultaneously. He punches one fellow, he's about to fall down, he punches the next fellow. By that time he falls down.
Yes, the pillion rider, while I was punching the pillion rider, PW4, and he fell down. Not due to my alleged punch on the victim, my lord. That is what. It is important, my lord.
Okay.
And para 7 also says that without consulting a doctor, the blood was...
That would be the immediate cause of death.
Yes.
The immediate cause of death would be because he took away the cotton from the nose and he bled.
Yes, that is
But the post-mortem report says he died because of the hemorrhage in the brain. From the brain, everything was flowing out, he removed the cotton, he died. In any case, he would have died of the hemorrhage. Now you have to find out whether when you pushed him or boxed him or whatever you did, could you have the knowledge that such an act...
That is what, my lord.
And did you intend to kill him or did you intend to...
The evidence did not, because the onus of proof lies on the prosecution, as your lordship also knows. No, the evidences on record did not show anything that I had that knowledge or I had the intention, my lord. And page 18, para 9 also, my lord. This PW4 did not know in which part of the body of the victim that I punched. But another eyewitness is page 19, PW5, my lord. Page 20 is the cross-examination. This PW5 is also...
Just a minute. I was reading a 313 statement.
Yes, my lord.
Then I applied force on him, page 5. What is this fee? Fee means to push.
Page, my lord.
Page 5.
I applied...
Para 5.
Yes, like if a person
like
is called on the shore, like pushing him, my lord, in this way or that way.
Okay. You were saying, you were taking us to which page?
Page 19 is the examination in chief of PW5. Who I am taking out is he is also one of the eyewitnesses. It appears that this is one of the neighbors, my lord, who was staying at the place of occurrence. But she said at page 20.
Just a minute. I did not see the accused assaulting anyone.
Yes.
But then how do you explain the injury to the face and to the base of the skull? Base of the skull has to be this part. face has to be disparate. How can he be injured on both these sides if you have not punched him? Because of a punch, he would fall down behind from the scooter. And then he would injure his skull. Now, if the hemorrhage is here, probably you did not imagine that he would have fallen down that way and the injury can kill him. But if the injury is in the frontal part of the face,
I don't know which way,
that is like,
which part of the head was hit while he was falling down.
no,
But
the post-mortem, the doctor says the base of the skull is broken. Where was it? He was PW number?
PW 11,
11.
Page 29.
Yes, you see, that is why I was trying to find out which is the occipital part.
Multiple small abrasions
We
were
leave that
found on the
apart.
front of the neck.
And hematoma of size was found in the occipital part.
Occipital.
So the hematoma means it is the blood clot. That is where the blood leaked
Yes.
inside the head.
Yes.
That is hematoma. So hematoma on the occipital area, which is the occipital area. Then if you come, the next sentence, skull base was fractured.
Yes.
So two things could happen.
Mm.
The hit is on the front, blood leaks inside. He falls behind, breaks his skull at the base also. Two injuries at the same time. Now hematoma is the cause of death as per the doctor. So that leak which took place in the front part is the reason. He removed the cotton, thereafter he died. Immediate cause may be the removal of the cotton, but the cause of death would still be the hematoma here.
However, Lordship,
Now if it was one, if we take it to be only one box, he boxed him one punch. That is where we have to see whether the knowledge or the intention to kill could have been there.
Yes.
Or was it to...
and the PWs, all the prosecution witnesses, stated that they had retracted their statement, even though they stated in their examination in chief that they saw me punching. But they stated in their cross-examination that they did not see, my lord. So that is also quite relevant.
And how does the trial court deal with it?
And the trial court stated that mainly it was based on the evidence of this PW3. That is, who made the judicial confession under 164 CRPC. This the conviction is mainly based on this judicial confession of the PW3.
Where? Which page?
Page 53, 54. And also based on the other eyewitnesses, like PW4, PW8. PW8 is also the one who rode in the scooty with the victim. But he fled from the scene. Before the incident, alleged incident happened, he fled from the scene,
Who?
PW8. So he did not see anything. He said in his evidence, my lord.
No. Something had happened on that day is inevitable. You were involved is inevitable. We cannot deny that. Only thing is that whether the act that you did, whether a punch or a push,
Yes.
whatever it was, can it be held that you had
That
the
is what,
knowledge
my
and the
lord,
intention?
That is my main contention, because two things we need to consider, my lord. Whether intention to cause death by doing my act. Another thing is that part 2 will be whether I have the knowledge that my action will be likely to cause death to the victim. But evidence of the prosecution witnesses did not make out anything. That ingredient, my lord, ingredient was not made out.
The court has rejected that you hit him again.
Yes.
Court says you have not hit him again.
Yes, that is what.
It is only one punch.
Yes. That is what this PW3 had also stated in her judicial statement.
Small cut above left ear, half inch. The back of his head swollen about 1.5 inch. That is what.
My lord, my humble contention, for an example, after he fell down, suppose it is admitted fact that I hit him again and again while he already fell down on the road. Then that could be that intention or knowledge that will likely be caused to him.
No, this is what
That
we
is
are
not
reading.
the case.
Para 22 of the judgment.
Yes.
The PM report indicated the victim's cause of death as coma caused by intracranial hemorrhage. है ना?
Yes.
And then prior to that we have back of his head swollen about 1.5 inch.
Yes.
If there is nothing on the face, then when a man falls down, he might hit his head anywhere.
And he
Can
was
knowledge
drunk
of that
also,
be-
my lord. He was drunk. The victim was drunk.
That will add to your agony, because if you are pushing a drunk man who cannot control himself, you should know he may fall down and die.
What I'm
Let us
trying
not
to say
impress
is-
on that. Huh?
What I'm trying to say is that, my lord, it appears that he could not control himself.
So you should not have pushed. Why did you push?
But I didn't know that he was drunk, my lord.
Then how can you say now that he was drunk?
It was
This is exactly what they say about beating around the bush. You know? You can't do that. You can't go round and round trying to find something. See, there was no, you did not know each other, there was no animosity between you. Whatever happened at this part of the moment. You either pushed or boxed.
Yes.
Now, the only thing that I need to understand is, where was that hematoma? If it was on the front part where you could have boxed, then the result will be different. And if it is a push, if someone falls down and hits his head hard, maybe grievous injury, maybe injury, I don't know. But the intent and knowledge that one can die that vanishes.
Because it
26 they have said.
Because, my lord, it has to be beyond reasonable doubt.
As was likely to cause his death. Intentionally caused bodily injury as was likely to cause that. So you say that you did not have the, where is that, what is the ingredient?
299.
Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life. Whoever causes death by doing an act with the intention of causing death, that is not there.
Yes.
Intention of causing such bodily injury as is likely to cause that, we'll look into it. with the knowledge that he is likely to cause that.
My lord, page 57, para 20, the judgment is also, even the learned trial court found that there is no evidence. Page 57, para 27, my lord. The learned trial court also stated that although there is no evidence that
So
the
I'm
accused...
saying the intention, trial court says is not there.
Yes,
Intention to cause that is not there.
yes,
So it is intention to cause an injury which is likely to cause death, or knowledge that it may cause death. Either of the two had to be there for you to be convicted.
yes,
Intention to cause bodily injury as was likely to cause death.
yes,
A punch or a push
yes,
is the intention that to cause such injury that a person will die on the spot.
yes. Even that, this second part, para 27, it was not proved at all, my lord. I have some citations also, my lord, to support my contention.
Yes, what citations you have?
The first one is, my lord, 1996 6 SCC, 1996 volume 6 SCC 129, para 20,
Para 20.
para 20, my lord.
Okay.
This is a long paragraph, my lord.
Yes.
Although it merely mentions about this framing of church in this particular case which I am citing, my lord, but it mainly says that there should be prima facie show that the ingredients should be completed, my lord.
There must be numerous judgments on push and pull or a box to the face, whether it would amount to
Yes, I have
this
done the
circumstance.
research, but particular that the specific one is I could not find it, my lord. So why I am producing this is that the ingredient part. This page 157 placenta B. It also says that, my lord, the material relied upon the prosecution for framing of charge under 304 part 2 must at least prima facie indicate that the accused had done an act which had caused death with at least such a knowledge that he was by such act likely to cause death, so and so. But the evidence of the prosecution witnesses did not reveal anything like that, my lord. And another one is 2000 volume 9 SCC, my lord.
What is this 2002? You have given a 2009 also.
Oh yeah, I have compiled it, my lord. The compiled one is given to your lordship, I think.
Okay.
The first one is 1999 volume 6 SCC.
Then the second one is 2009.
Second one is 2000 volume 9 SCC 1.
No,
Para 14.
just a minute. Just a minute. Just a minute. 2009 SCC.
2009 SCC 1. Para 14.
You want para 14 of it.
This is also regarding the ingredients. My lord, here in this cited case, the accused hit with a danda on the vital part of the victim with such force, with the knowledge that he will meet his death. And in that case, it may fall under Part 2 of Section 304. But this is not the case in my present case, my lord.
So mere boxing of a person, whether you can have the knowledge that he would die of it,
Yes.
or whether you intended to hit so hard that he should die of it.
Yes.
These are the two things.
Yes.
that we should.
Because merely pushing or for assuming for a moment that, but not admitting that I punch him, that mere punch on his face. No, in general thinking also, we can conclude that normally death would not be caused to any person, my lord. Then that punching part also not proved in the evidence.
So at best it is a push.
Yes, it is a push.
What about this 2009-17?
2009 Para 10, my lord. This is regarding 304 Part 2.
Para 10.
Para 10. It also pertains to the ingredients. Here in this cited case, my lord, there was a blow with a pair of scissors on the vital part of the victim. There is intention or knowledge is there in this cited case, but that didn't happen in my present case.
He had knowledge.
Yes, this is why I'm citing
Pair of
this.
scissors can kill.
Yes. Then I didn't use any weapon. It was a mere push.
You did not use any weapons.
Yes.
Okay, and what about this
And
2023?
2023 is it mainly relates to circumstantial evidence, my lord. But Para 17, I would like to emphasize this, my lord. The prosecution must stand or fall on its own legs. Para 17, because it is only the prosecution evidence. The prosecution has to prove from their own evidences. They cannot take strength from weakness of the defense, my lord. Prosecution evidence has to stand on its own legs. So they fail to prove.
Okay.
Even 304 also, my lord. These are the main issue, my lord.
How many years? Sentence?
7 years, rigorous imprisonment. And now I'm 26 years old, my lord.
Okay, 7 years. So from 23
Yes.
is there till 30. Yes, madam.
Please, Your Lordship. First of all, my lord, yes, Your Lordship, we have any queries? First of all, my lord, I like to say that there is no infirmity with the judgment. In fact, the learned trial court has shown leniency and has given only 7 years imprisonment. And my lord, the story, as you can see, is that my lord, PW number 4, PW number 8, and the deceased, they were at the spot and they were just talking to themselves. And the appellant advanced towards them and just give them a punch. So, my lord, we can see the wild nature of the appellant here. And not only that, my lord, we have an eyewitness. And the eyewitness, this is a very important witness, my lord. In fact, she has given her judicial statement. And in the judicial statement, we can see that, my lord, at page 87, I think I'll have to read this, page 87, my lord. Page 87, the last question, my lord, at the bottom. Please narrate the details of the incident. And the answer: it was a Sunday evening and I was cooking dinner when I heard loud screams from outside. I looked out from our window and I could see two people on a scooty arguing with Jonah. The engine of the scooty was not switched off and the pillion rider, whose leg was partly lifted, was about to board or either get off from the scooty. Jonah boxed this person with force, my lord, with force here. And this is the deceased, my lord. Jonah boxed this person with force and he fell on the hard floor and he no longer moved. When I tried to go out, my mother stopped me and so I continued watching them from my window. The scooty rider, who was deeply scared, ran towards our home. He was chased by Jonah. See, my lord, he was also chased, even the other rider. He was chased by Jonah, who managed to box him on the face. Again, after chasing, my lord, he boxed the scooty driver. However, the scooty rider scurried away. I stayed where I was and Jonah came back here, my lord. This is very important. I stayed where I was and Jonah came back and once again hit the unconscious person on the floor, saying, "So you guys were trying to fight with me." So this is the second time he hit the deceased, my lord. So from the statement of this PW number 4, not PW number 4, my lord, this is the statement of PW number 3. And the statement of PW number 4, who is the scooty driver, and another one who is their friend, the third person.
Now, when
PW
in her
number
cross-examination, PW3 says, this judicial statement that you are saying, that was without a cross-examination in front of a magistrate.
3. Yes,
No cross-examination, nothing. But when she was brought to the court,
yes.
she says, I did not see the accused assaulting the injured.
Yes. Yeah, my lord. It is a fact that I did not see the accused assaulting the injured. The injured means the scooty driver.
The person
not
who
the
did not
deceased.
die.
Yes, not the deceased. Injured. So it can be presumed that he has not seen him hitting the injured.
Because she does not say it is the deceased, she says injured.
The injured, yes. And in her statement, my lord, she has stated that I may state that at para 3, my lord, I may state that apart from the statement that Jonah Atu, a Chakste Pagi himself, Khela, purportedly recorded as stated by me, the rest of the statements are made by me. I did not make the statement. So, my lord, she has stated that she gave the judicial statement.
Okay,
She
so
has not
your
retracted
argument
it.
is that she does not retract from her statement that the deceased was hit.
Yes,
She says, I did not see anybody else being hit.
yes.
Okay.
The injured means maybe some other person.
Other person also, okay. Now, what do you say, even if he suppose has hit,
My lord,
was
the
it with the
result-
intention, whether it was with the intention or knowledge to cause death?
My lord, as the learned trial court has pointed out, there was no intention to cause that maybe, but he has intentionally caused bodily injury as was likely to cause that. So he has punched him hard and he fell on the floor. And after running after the rider, the scooty rider,
came
he
back
came
and
back and again punched him. So there was some knowledge that such bodily injury can cause that. And we have the statement of PW number 8 also, my lord, who was also present while this person, while this 3 persons were just standing and talking, my lord, the appellant came and advanced towards them and just hit them. So,
No, that he hit the motionless victim again and again. That has been discarded by the trial court. If you come to page 55, the last paragraph, The second hit, which you are emphasizing, that has been discarded. Last 4 lines, even though. Can you find that line?
You know, the prosecution has contended that the accused had hit the motionless victim again. It is found unsafe to rely on the contention as the said eyewitness had retracted from her earlier stance, saying she did not see the accused assaulting the injured.
So what the court understood was that assaulting the injured again has been retracted. Therefore, there was no second hit. So we'll have to confine to the first
The first blow.
blow.
The first blow is sufficient, my lord. This PW number 3 has said that he gave a hard blow. That is sufficient to cause that, my lord.
But a blow to the face would be a black eye, some bleeding, pain for some days. Is it with the intention of causing death or knowledge that one blow will kill a man?
My lord, if someone boxed some person with a full force and he fell down on the floor, my lord, the knowledge is that such injury can cause that, my lord.
So they say that because it was in the heat of the moment, 304 will come in. Exception, है ना?
Yes, ma'am.
Then he wanted to cause a body, he intentionally caused such bodily injury as was likely to cause his death.
Even in his 313 statement, my lord, he did not deny that he used force. He did not deny that he used force.
Circumstances in that situation, the circumstances are not such that someone would have the knowledge or the intent to kill. If it was a communal riot, there were some slangs used. Those kind of situations, one might think that, okay, hit with the force to kill. The anger goes to that limit. Someone is making noise. Someone is not appreciating the noise. They start into a scuffle. One finds himself to be a local person and the others not to be so local. So, thoda dadagiri maar diya ghusa. Now what happens? Is it with an intent or knowledge to kill? Or because the book I am reading, this one that I am reading,
Yes, my lord.
it says, the intention of the accused must be judged not in the light of the actual circumstances, but in the light of what is supposed to be the circumstances. So, someone was making noise, he asks them to shut up, they do not, and fisticuff, he goes and gives the blow. Are the circumstances such that he would want to kill, or he would have the knowledge that I will do this which may kill him? Once we accept that it is in the heat of the moment and due to a sudden quarrel.
Yes.
We are not saying it from our side, we are saying it from the side of the judge. The trial court, he says, a sudden fight in the heat of passion, upon a sudden quarrel, would the knowledge or intent to kill come? Or
Exception 4 to section 300. madam. It's committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner.
so there is no act of cruelty,
Yes.
there is no unusual manner. Now if we say that he came back and he started to hit him again, that would be cruel or unusual.
Yes.
If we say undue advantage, man lying down, he is trying to kick him, that's an undue advantage. But he says it is a sudden fight and a heat of passion upon a sudden quarrel. So would the intention, can the intention of inflicting injuries, having the force to kill, can it be imputed unless some more action is proved? That is where we are finding it difficult to agree to the findings of the trial court. Otherwise, yes, say 23-year-old man hitting a 72-year-old person on the ribs or on the face, yes, the knowledge that the old man may die, that would come in. But here the victim, the deceased is not so young. 3-4 young boys, one hitting the other. Can the intent to kill or knowledge to kill be imputed?
Intent to kill or knowledge may not be there, but the death was the result of the assault. That cannot
But
be
then
denied.
but in criminal law we punish the mens rea, we don't punish the actus rea. The act is not punished, the intent behind that act is punished. So now if someone wants to give a simple injury, by chance the other fellow dies, he is still punished for simple injury, not for the death. If someone wants to give a grievous injury but the other fellow dies, then also it's a punishment for grievous injury, not death. It is only when you intend to kill or you know that it can kill, only then that bad mind, the criminal mind has to be punished, not the act. Here we are not finding that ingredient till now. Maybe if we read some little more, we may find something. But till now we are not finding that. Yes, anything more to submit?
My lord, trying
should we close it?
to refer the injured person as trying to refer the injured person as the other person other than the present victim.
No, that argument already goes,
Yes.
because if you come
It's
to
not correct. It's not correct. my
if
lord.
you come to the
Page
trial court
55.
version itself,
Page 55.
yes, he says,
The
the
injured
said
person.
witness has
yes.
retracted from her earlier stand, stating she did not see the accused assaulting the injured. So this
Exactly.
coming back and hitting the same person is what, it may be right, it may be wrong, but the trial court is understanding that he did not come back and hit the injured, means he did not come and hit back the person lying on the ground.
The injured person is the deceased only, my lord.
So therefore the repeat attack is not
Yes. that is-
trusted, but the first blow is trusted.
Very crucial in this.
From my from
And
my
we just have to see whether if the first blow is with an intent to cause an injury which may cause death,
Yes.
or with the knowledge that
Knowledge,
the injury may cause death, or was it one punch, one fight,
Yes.
and fate takes over.
Yes.
Yes, anything more to submit?
No, my lord. I'll conclude my submission.
Madam? Close it.
Yes, my lord.
Any more matters for today? For which matter?
There's a supplementary cost list.
Supplementary cost list.
And one hearing as well.
What are the supplementary matters? I don't have any supplementary list. Which is the one? Huh? I don't have any supplementary list with me. Huh? Is he there? Is the council there? We are keeping it CAV. You'll have the judgment by Friday or something.
My lord.
else. She's there. What is that bail? What is the bail, ma'am? Have file.
My lord, this is fixed. It's fixed for today. The bail. It's NDNPS case. NDNPS case.
At 2, or you want to do it now?
No, my lord.
If
As
you are
per
comfortable,
your-
we'll do it now. Take a quick break. We don't come back. If you want to do it at 2, we'll come back at 2.
Yes, my lord. We'll come at 2.
2.
Yes, my lord.
Okay. Take it. We'll assemble at 2. 3 matters more, na?
Yes, no, 2 matters.
2.
Yes, 2 matters.
2. We'll come back at 2. Yes.
Item number 19.
My lord, this is bail app. If I may please your lordship.
Yes, that's surgery.
Yes, my lord.
Some surgery was required to be
Performed.
performed on her.
Yes, however, her vitals are not stable yet. So her vitals are not stable yet. So that's why the operation has not been done yet, the surgery.
Have you received the CD? Updated CD, madam?
Not yet, my lord. The case is from Longley district.
Okay.
My lord, we had annexed the charge sheet. Everything is, we have annexed the charge sheet. Everything is there in the charge sheet, my lord.
Oh, it is now in trial.
Yes, my lord, it's at the stage of CC. Charge consideration. Trial is about to start. There are 12 witnesses. Their charge is framed against 2 persons.
Why was the bail recalled? She was given bail, na?
She was on interim bail.
Interim bail.
Yes, my lord.
Then what happened?
And then after that, it was extended. And however, in the last bail order, it was rejected. My lord, if I may take your lordship to the brief facts of the case. The brief facts of the case is that one vehicle was, from one vehicle, there was a seizure of 601 grams of heroin, suspected heroin. And from there, it was from the statement of the driver, the instant applicant is arrested. My lord, if I may read page 43, the brief facts of the case of the prosecution story. My lord, here it is stated that the vehicle carried large sack intended for Lalding Pui. However, my lord, nothing was written. Her name was not even written there in the conveyances or any of the parcel, the outer coverings. And when inventory was done, nothing was there in the inventory photographs as well. There was nothing on records, even in the charge sheet, to incriminate the instant applicant in this case. However, the driver, from the statement of the driver, it was stated that that was intended for the instant applicant. And he was not even arrested. The driver of the sumo, of the vehicle, is also not arrested. And in fact, he became the prosecution witness.
But here it is that the vehicle was stopped, page 43. The sack was opened and inspected in presence of the owner, Lalding Pui.
Yes, my lord. Again, he was summoned. He was at her shop. She owns a shop in different location. And then from the interrogation of the driver, of the sumo driver of the seized vehicle, then Lalding Puyi was summoned, the instant applicant.
Now you are in custody.
Now we are in Guwahati, in the hospital, waiting for operation.
Are you admitted in the hospital? No. You're waiting at Guwahati?
We were admitted in the hospital on 31/10/2025 for surgery. However, some of her vitals were not.
stable.
She was not fit
So?
to. Yes, she's not fit for surgery yet.
So she
And
was
so
released.
This week, I don't know about release. However, they will do some blood test again this week, and if she's stable, then she will have her operation. And also, my lord, in this case, there are lots of mandatory violations, mandatory sections violation.
The
Article
co-accused
22.
is on bail.
No, Your Lordship.
Yes.
No. She's on bail, yes, my lord.
You have the file, page 147, you can see. What was her role according to the police?
The applicant,
No, the other one who was released on bail.
from the statement, she was also involved in the procurement of the heroin.
Your Lordship, if I may, in this present case, the actual owner is the present appellant. And moreover, the present appellant, he is a habitual offender under section 21B.
There are other cases pending?
Yes, Your Lordship. He even have pending cases
There
at the
is
moment.
one
And-
pending cases, 21B, that, my lord, that she, in fact, she became the suspect. However, there is nothing, it was just from the statement of the accused, and which is not admissible
And Your
as per
Lordship,
section 67 of the Indian
The
PSF.
issue is not whether that case will stand its merit or not. While
Same
granting
here.
bail, we have to see whether the person will repeatedly commit the offense or not.
No, my lord.
Now, already in another case she was involved. This is the next case coming up against her. That goes against the
My lord,
petition. Huh?
these are just an allegation. so
Why
far.
victimize her? Why would the narcotics department victimize her all the time?
Because from the statement of, that we do not know, my lord. That is
And
why we
another
have
thing, Your
approached
Lordship,
this
if I
honorable
may
court,
take
my
you to
lord.
page number 37. Page
37.
37. That is the bail rejection order. And even here it is clearly written that the accused petitioner had committed similar offense under section 21B while on interim bail. And another thing is that, Your Lordship, the appellant went to Guwahati without taking prior permission from the
Where
trial
is
court.
that interim bail?
The interim bail order, the second
34.
interim bail order is in page number 34.
Yes.
And as per my verbal information, Your Lordship, the trial is pending, and it is pending at the CC stage, charge consideration stage, because the appellant is abscond. And now the trial court has issued notice to the surety, and even the surety hasn't turned up to the court till date.
My
No,
lord, she
this
has
should,
not absconded.
page 34 is extension for one more month. One more month.
1 more month.
Where are the terms on which she was given the interim bail?
The terms were not written here. I believe that
First
the
order
terms
of the
were
bill?
written in the first order,
Huh?
but the first order was not annexed here.
The first order is not here, madam?
My lord, there is no condition that she has to take the leave of the court to go outside Mizoram.
Where do we find it? Where is that order?
My lord, the first order was not annexed.
You have to bring on that. You have to bring on that. Because two things are disturbing this court. One, you have left the jurisdiction of the trial court while on bail without informing the court.
My lord, there is no such condition.
Thing is, the bona fide acts. One application that I'll be going to Guwahati, I would need my treatment, this is my contact number, please allow me to go. That's an information you need to give. And secondly, this finding that she committed a similar offense while on bail, that is something which is disturbing us. Because the 37, I think that is the rigor of 37, that
Yes,
she will
exactly.
not commit the offense again.
Exactly. Your
That
Honor.
is
My
one
lord,
of the...
in this 21B, which they have alleged that she committed while on bail, is 21B. So section 37 is not attracted. And also in the 21B case, there was a recovery from on the roadside. And on mere suspicion, since she already has a case, then on mere suspicion, my lord, she was again arrested. No recovery was found on her. That, my lord, I can produce the charge sheet as well.
You have the order, the first bail order.
The first order...
Do you have a copy of that order?
No, not my lord. Not with me. And also, my lord, there are a lot of mandatory provision violation, constitution violation as well.
Which violation has been made? Tell us.
22.1 as well.
Huh?
22.1 as well.
Which one? Where? Where do we find it? From your...
That, my lord,
Show us from here. Because 21 will come in. This is an arrest with warrant. You see page 55, the warrant of arrest is there.
Yes, Your Lordship, the warrant of arrest is there.
It is there.
And with regard to the warrant of arrest, there is no need to write down the grounds of arrest, and I have a citation for that one.
Yes, can you produce
then,
that?
my lord, with regard to the warrant also, we have made submission regarding that. The warrant of arrest, my lord, warrant of arrest is signed. There was no date as per the schedule.
It may have your
22-12,
case
my
may,
lord, my
your
lord.
case may have so much of merit, but then to convince us on the bail
Yes,
for
my
the
lord, I'm
present.
coming to that.
Huh?
I'm coming to that, my lord.
We believe the medical documents, but this treatment can be given to her through the court also.
My lord, if I may read my application at page 4. Page 4 of my application.
Page 4.
4.
4, how can there be an application?
Bail application.
Page 4 of the bail application, yes?
My lord. If I may read the second paragraph, it is pertinent to mention that the complainant, the seizing officer's statement is inconsistent in his statement and documents annexed in the charge sheet. The SO stated that he received information at 2:30 p.m. on 22/12/2023, and in some documents prior information was received at 5:30 a.m. on 22/12/2023. Also, the SO recorded information under Section 42 NDNPS Act as he could not obtain warrant of arrest. However, warrant of arrest was duly obtained on 22/12/2023 from the Chief Judicial Magistrate Lunglei, but not in compliance of second schedule Form 2 of the CRPC, as there is no name, seal of the magistrate and date. it is tried to mention that the CJM has seen the application for WA on 23/12/2023. However, the warrant of arrest was dated 22/12/2023 in her signature, which created doubt in the way the investigation was conducted by the prosecuting agency.
I
That, my
think
lord,
this bail would have been extended if the 21B would not have come in the way. They would have extended it. But this 21B again getting caught with the same thing.
that, my
There
lord,
37 comes in.
yes, the CJM has put her
Whether,
signature.
if in one case someone is accused of possessing, in the other case he is accused of transporting, in the third case he will be accused of manufacturing, can we say it is not the same offence? It is the same offence related to NDPS, not letting go.
See, my lord, since she already has this 21C, on mere suspicion, there is once, my lord, if you go through the charge sheet of the 21B, then we can have.
Where is that?
I can submit. I can file it tomorrow or today.
Today, how
and then
can
we
you
can list it tomorrow.
Ah.
Additional affidavit as an additional
You
affidavit.
do it on Monday. Take a chance on Monday, because we are not finding much grounds to.
My lord, there is clear violation of Article 22(1) as well, because the warrant of arrest was dated 22/12/2023. However, the magistrate saw the application on the next day, 23/12/2023.
Your Lordship, in that regard, how can we believe that the magistrate has seen that application?
It's
Now,
in-
the
it's in
magistrate,
the-
we have seen the signature of the magistrate putting the date, the 22/12/2023.
Where is it?
So, that is in page 56.
56.
Mere submission that the Chief Judicial Magistrate have received the application on 23/12/2023 cannot be accepted.
My lord, it's in the charge sheet, but I've just missed it. But it's in the charge sheet, that I'm sure. Otherwise, I would not have made submissions on mere presumption.
No, the Chief Judicial Magistrate, this application you are saying does not contain a date, is it?
The
Page
application.
54? Page 54 you are saying does not contain a date.
Yes, my lord, as per the second schedule.
Page 54 does not contain it. But the warrant is at page 55.
Yes, my
That
lord.
contains a date, 22/12.
Yes, my lord, with regard to the warrant only, I was saying that because the application was seen on 23.
Even the application is dated
No,
22/12.
this will be also produced at the time of producing the, what do you call the arrest, the accused. Then this scene may have come. But when the judicial magistrate puts his seal and signature on 22/12/2023, why should we disbelieve him?
My lord, there was an application, but I couldn't locate it. That it was seen on 23rd. The magistrate herself had.
Yes, yes, it is there on page 54. Take page 54. That round, it's rounded in pencil, you see? Or it is not there in your copy, it is there in my copy.
It's there.
It is there, no? Scene 23/12/2023. That is what you are saying.
Yes, my lord.
That is 22 or 23/12/2023, we understand that. But here, another factor is at the top, it is dated 22/12/23, and on the next page, the warrant itself is signed on 22/12. Now, either we have to, if your argument is accepted, then we have to hold that this Chief Judicial Magistrate is signing it backdated. Why should we believe that without any proof? No? We cannot hold
Yes,
that.
my lord, because why would she sign on 23rd again?
This is the 22nd.
And also 22nd is also, she signed it seen on 23rd.
So this
12.
scene might be wrong. We'll take that the scene date is wrong. The
The
rest to
application
22.
date is 22/12.
22/12 is also
The
the date
application date.
is
Applied.
overwriting.
Huh?
Yes, overwritten.
It is not overwritten.
Yes, it is.
Hey.
You are looking at page 56.
I'm looking
That
at
is
page
for
54.
Zonanpui. But on page 54, I don't see any overwriting. Page 56 might be there is an overwriting on the 12th. I don't know.
Page 56 is for the co-accused. Yes, this is
Page
also.
54 is for accused.
Yes, 56 is for the co-accused.
Co-accused. She's on
Yes.
bail, there is no problem.
23.
And her bail granted is okay. She is not wanted in any other case, so she is not involved. This lady apparently is involved.
But my lord, how can we say that she's involved because she's not convicted yet?
21B. She's involved in an, okay, we'll put it this way, she's involved in an allegation.
Yes, my lord.
Not in a crime, but in an allegation. But still, that has come up, no? And as far as the treatment is concerned, perhaps with appropriate medical documents, you can be referred to some hospital for treatment if required. Not necessarily bail. What do you want to do? Get your earlier order, which Madam says has conditions. Maybe you can produce that order to show that no conditions and there is no requirement for you to tell the trial court before you leave the station. You have not only left the station, you have even left the whole state,
My lord,
gone out
there
of
is no-
jurisdiction.
Even before this, she has gone to Guwahati for checkup.
could
And that medical was already submitted before the trial court as well.
Could be, but during trial it is, once the
There's
person
no
does not
specific-
inform.
There's no
yes, the
specific
person
condition
does
which
not
bars
inform.
the applicant.
Okay, we'll list it when? Monday?
Yes, my lord.
24th? Have
Yes,
it
my
on the
lord.
24th.
Obliged.
Heard Ms. So-and-so. Learned Counsel appearing for the applicant, also heard Ms. So-and-so, learned additional PP. Ms. Fanai, learned counsel appearing for the applicant, has prayed for an accommodation to produce the first order granting bail to the petitioner. Stop. Can you trace out, don't write this, can you trace out that 21B charge sheet? No.
Yes, my lord.
Have it ready to show what
Yes,
are
my
the
lord.
charges against her. Prayer is allowed, let the matter be listed again on 24th of November 2025. You
Obliged.
try and get that order, try to get the charge sheet file, we shall see them if we are
Yes,
here.
my lord.
Hearing item 19.
Item 19. Why am I not getting the supplementary list? Huh?
May it please your lordship.
Yes.
This is an appeal against the impugned order dated 17/12/2024, passed by the Court of Civil Judge Senior Division 1 Aizawl in CMA number 462 of 2023, whereby the appellant's application for setting aside ex parte judgment and order was rejected.
Where is that order?
The order is just after the index, my lord. The operative portion starts from Roman number 7, my lord. Paragraph number 9.
Who are the parties?
The
What is the fact basically?
The fact of the case is that the appellant is the junior engineer, junior engineer employed under the PWD, Government of Mizoram. And he was the supervising engineer for a contract work, which was undertaken by the respondents number 2 to 6. And the respondent number 1 is the owner of an excavator which was hired for executing the said contract work. And this respondent number 1, believing that the present appellant had taken up the contract work for his own benefit, had filed a civil suit, filed a money suit, claiming a sum of rupees 20 lakhs and 20 lakhs above, my lord. And that case was decided ex parte against the present appellant. And the appellant had filed an application before the trial court for setting aside the impugned ex parte judgment and order, saying that he was not the contractor in the said work, and that the said contract work has been performed by one person named Sujata Chakma, who executed the contract work on the basis of a power of attorney executed by the present respondent number 3. And he had also collected all the final bill, which amounting to rupees 52 lakhs 1,364. And though the facts was produced before the trial court refused to set aside the judgment and order, and now the appellant has a liability in terms of the impugned ex parte judgment and order, my lord. So we are before this court
Yes,
challenging
so how do you explain your absence?
my absence, my lord. My application for setting aside the ex parte judgment and order is at page 14 of the memo of appeal, my lord.
Page 40?
Page 14, 1-4, my lord.
Yes.
The operative portion would start from page number 16. And with your lordship permission, if I may read.
No, don't read the whole thing, just tell us.
Yes. My
Where
grounds,
do you explain
yes. My grounds in the application.
During the proceedings, someone supreme misconduct for things of the same was allowed when it is deemed a notice by the newspaper. Then, please tell me one thing.
Yes, my lord.
The order.
Yes.
Which is impugned here.
Yes, my lord.
It says, perusal of record shows that summons dated para 9, I am reading para 9.
Yes.
Perusal of record shows that summons dated 7/4/2015.
Yes.
Clearly shows that the applicant,
yes,
defendant number 1 himself had received and signed the summons.
Yes, my lord.
And here you are showing about a paper publication.
Pardon, my lord?
You are showing a paper publication at page 17.
Yes, my lord.
So whether you received it or whether it was paper
My lord,
publication.
there is a summon which was purportedly signed by the present appellant. But comparing the signature, even we have mentioned in the grounds of the appeal, by even to an untrained naked eye, my lord, it is completely different, the signature. So we have not received anything. And we
Yes,
were,
can you explain?
Yes.
If he had received the summons,
My lord.
then why the paper publication?
my lord,
My
that
lord,
is
because
for them
he,
to-
in fact, my lord, there were two summons that was issued to the instant appellant prior to the issuance of this newspaper publication. One was on 07/04/2015. This is at page number 124. 124. And thereafter, another summon was issued to the appellant on 28/06/2016. This is at page number 125. And this have been sent through the OC Sitewell Police Station. And on, if your lordship will see at page number 124, the appellant herein had subscribed his signature.
Yes, my lord, this is the signature that I was talking about. It is completely different, even
You are
comparing to the...
you are not following me, or I am not being able to follow you.
Yes.
Come to para 9 of the judgment which you have impugned. Please come to para 9 of the judgment.
Yes, my lord. I have come to that. Perusal of the report
Perusal
shows
of
that-
record
yes.
shows summons dated 7/4/15.
Yes.
Clearly shows that the applicant defendant himself duly received and signed the summons.
Yes, my lord. This is the.
So already if it was received on 7/4/2015,
Yes, my lord.
what was the necessity to go for 2016 again summoning him? That is what I'm asking you.
My lord, because in spite of the receipt of the summons, the appellant did not appear before the trial court. That was why.
Where is the, once a summons is received, why should summons again be sent?
My lord, that is there, my lord.
It is not inspiring. Something is wrong here. What is?
Yes, my lord, exactly.
Something is wrong.
Even comparing the signatures appearing in page 124.
Then again,
with,
Acha, you tell me this, even after the ex parte order was passed,
Yes, my lord.
applicant, defendant number 1 continued to appear before the court on 18/2/93 and 13/5.
Yes, my lord.
If you did not receive summons, how did you appear?
My lord, thereafter I received another summon in 2020. That was during the pandemic. And I appeared before the trial court. And these, the order that were passed on 18/2/2020, 9/3/2020, and 13/5/2020 can be seen.
Then you did not go through the records to find out that there is
in
an
my
ex-
application, my lord.
No, no, you
Page-
did not try to find out whether it is ex parte or not.
My lord, I have no control over the case record. It was during pandemic. And I appeared before the trial court wherein on all those 3 occasions, the respondent number was
Is this order, huh?
who is the plaintiff therein was absent, my lord.
No,
And-
but then the judgment came on 13/12/2021.
Yes, after the pandemic, the court was irregular. There was no functioning of courts due to several lockdowns imposed by the state government. And thereafter, the trial court even informed me that since he was absent for 3 consecutive occasions, the case would be dismissed. And however, I was hit again with the ex parte judgment order, and I have not received any summon or anything after the lockdown was lifted. That is my case, my lord. And clearly, my lord, this plaintiff, he had not made a truthful statement. He had played a fraud upon the court, my lord, by saying that I am the one executing the contract work.
That the court will decide.
That the court can decide.
If
So-
we send it back, that the court will decide who is lying to whom.
Yes,
We
my
will
lord.
not sit here to do that.
All I'm praying for is that to contest the case on merit, because your lordship can clearly see from page 132, my lord.
Page 132.
32. This is the power of attorney executed between the present respondent number.
No, we are not interested on the merits of the matter.
Yes.
Don't take us to the merit of the matter.
Yes, my lord.
Just show us why this ex parte order should be set aside and why you should be allowed to appear
Yes, my lord.
or contest.
Because, my lord, as I have mentioned in my application, my lord, at page
This page 124, what is it?
Page 124 is the summon purportedly served to the applicant.
So
appellant.
this signature?
The signature appearing herein is denied by us, and it is completely different, even comparing to the Vakalat Nama as well as the affidavit filed before this honorable court.
Did you change it recently or was?
No, my lord, you cannot change my signature. Yes, my lord, I was the supervising engineer. I am not the contractor. If I am liable for
Okay, so,
a
but
huge
this
sum of
was
money-
received by the junior engineer.
Yes, they have written my name, they have put some signatures, but it's not my signature, my lord.
Okay, then what about this?
The next one, 125, there is no signature. 126, there is some person by the name of Ma Omi, signature with a phone number, which is not me. So the trial court relied upon this and rejected my application.
Okay, on 19th of May, you are required to appear, but they have shown your receipt when?
That was also not.
Hmm?
And
14th.
even after this, my lord.
14th of May, it was shown to have been received by you.
Yes.
Hmm?
17th April 2015. And thereafter 28 June 2016 and 29 November 2019.
What is this? What is this written above the signature of the officer in charge, page 125? What does it say?
Page 125.
Huh?
Officer in charge, Police Station, Saitwal, Mizoram. Chal Chakima. I think he's a police personnel, my lord.
No, just above that, some chalta, what is that for? Necessary action.
Chakima.
Huh?
Sidal Chakima.
Okay, whatever it is.
Sidal Chakima.
Then where is this thing? That you were served with this?
My lord, there is nothing to show that I was being served this summon, my lord.
Where are the orders passed?
The orders passed.
The orders leading to this, all the orders of this thing? Yes. This was sometime in 16.
Page 66, my lord, page 65 is the order
From
for
2018 you are
substituted
putting up.
service.
These you have given from 2018.
Yes, my lord.
Where is the earlier part of it? Yes. Then in 2016 it was a paper publication.
Yes, 2016.
Yes.
And this was the reason for the ex parte judgment.
So once it is published in the paper,
it is published in Aizawl. I was posted at Saitwal, which is outside Aizawl. I was out of station for my government post.
What is this paper?
Wanglaini. It is circulating within Aizawl.
Is that so?
Yes, my lord.
Only within Aizawl?
No, my lord. In fact,
One district newspaper?
It's been
No,
circulated
Wanglaini
all
newspaper-
through the state of Mizoram, my lord.
It's not circulating throughout entire Mizoram. It's mainly circulating in Aizawl. My lord, the fact remains that I am not the contractor, and the ex parte judgment order is very wrong, my lord, because I am employee of the state and I have done my work by supervising the state contract work. And if I am liable to...
But again, you have already appeared before the court I
have appeared
during the
COVID pandemic. Yes, my lord, the orders will be there, my lord.
Huh?
The orders I have annexed in the memo of appeal, my lord. And if your lordship may kindly come to page 79, 18 to 2020. This is my first appearance before the trial court.
18
to 2020, page 79. Plaintiff is absent. Defendant number 1 appeared in person. Pro forma defendant number 1, 7, and 8 are represented by AGA. After hearing defendant
You are
number
defendant number 1.
Defendant number 1 is the present appellant, my lord.
What is his name?
PC Lalthamwana. I am the
Just a minute.
defendant number 1 therein.
Just a minute. Yes, can you explain this part? Come to page 73.
Page 73. Yes, my lord.
Okay. No, page 72.
Page 72. Yes, my lord.
No, it's not even page 70. Page 71.
my lord.
71.
Plaintiff lawyer and counsels for defendant number 6 and government advocate are present.
Yes, my lord.
Today is fixed for
P.
plaintiff evidence.
Plaintiff evidence.
Okay. PW so-and-so is present and cross-examined. On careful perusal of the
Records.
Materials on
Materials
record.
on records.
the defendant number 1, 2 have been
4 and 5.
absenting themselves for a number of time in spite of summons being duly received by them. Therefore, it is of the opinion that these defendants are not interested in the suit. Hence, the case is proceeded proceeded ex parte against them.
Yes.
Fix Iman for cross-examination of PW by defendant number 3. Then again it is plaintiff lawyer and counsels for defendant number 6 to 8 are present. Today is fixed for cross-examine. PU so-and-so is present. As the defendant number 3 counsel is absent, court presume that he is not interested. J also declined to cross-examine. Now why disorder then? CR put up today, plaintiff counsel submitted address of defendant number 1 as follows. Why did you submit that?
My lord, it seems that at the time of filing of the civil suit, the address of the appellant herein was Saitwal. And then thereafter, new address was given. And even in this page number 75, the address is given. And if your lordship will come
now,
to...
if the address, original address is wrong,
My lord,
then going back to the paper publication is wrong. If paper publication is wrong, he never had notice. If he never had notice, he should have notice to appear in the case.
my lord, at the initial period, and as admitted by the appellant himself, the appellant was posted at Saitwal. Accordingly, two summons and newspaper publication was issued.
Two?
Two
At his address in?
For the address in Saitwal.
So you were there? Yes, counsel.
And thereafter...
You were there?
Yes.
My lord, and someone's went there.
Someone's went there, but I haven't received it, my lord. As I've pointed out, the signature appearing is very different. It's not my signature.
Your lordship will see at page number 126. 126, page number 126. There is yet another summon served on the new address that was given at page number 75.
How do we say it was summoned? It was received?
Page number...
Page 126.
Where? Received is where?
Page number 126.
Where is it?
Just under, given under my hand and seal, there is a received number so-and-so, but to serve and return. This has been served by the
officer, this officer in charge is saying that he has received number 225 dated Iman that has been given to Constable
My lord.
Lalfam
Kima.
to serve and return.
My lord.
Now that it was served, where is that? Where is his signature?
And the signature, my lord, there is in the bottom, there is one written Maomi and the phone number was also given.
Is that his signature? What is your name? Laltham. This is not Lalthal.
Yes. This is a female name.
Lalthlamwana, huh?
This is the signature appearing on
It is not his.
page 26.
It is someone else.
Yes,
female name.
even assuming but not admitting that, my lord, the appellant herein has not been served in his new address. However, my lord, the ex parte proceeding has already been proceeded against.
That is what we are saying. If there is an ex parte proceeding, why summon him again and again?
My lord.
And if the summoning is done, then that summoning has to reach a logical end.
My lord.
Can it be
And,
kept hanging in the lurch? Okay, fine. ठीक है, summon कर दिया, अब नहीं करेगा. It cannot be like that.
My lord, your lordship will see at page number 124 the signature of...
See, what is the difficulty if he contests it?
Yes, my lord.
My lord, the facts is as stated by my learned friend is quite different.
No, you may have all the case against him, he may have all the defenses against you.
My lord.
This has gone ex parte.
My lord.
Record shows that no one was sure whether he was being served or not. Why
But
proceed
it's-
ex parte?
My lord, the learned trial court has clearly stated, had clearly recorded in the daily orders that notice has been served.
But then he also says that you are giving him new addresses.
My lord.
He says, okay, issue summon 29/11/2019. Then issue summon 27/11/2019. None of the defendants appear on 16/10.
And also, my lord, it is not the case of the appellant herein that he had not received the summons. He only stated that the plain copy was not received by him. No?
No, that is not, that is.
So, my lord,
that
he
is
knew that.
That is not service. If you don't give the copy to him, if you give him a notice and you say you come and appear, what will he do? Come and appear. What can he do? Even when we issue notice to the government, we say extra copies. They can take certified copies. Why do we give extra copies here?
That is there, my lord. But it is not the case of the appellant that he did not know that there was a case pending against him. That has never been pleaded by him. He knew that there was a case pending, and which has been stated by the appellant herein at page number 18. This is the CM application which has been filed.
See, this court which has handled it, I do not know. Come to page 79.
My lord.
Order 18.2.20. Have it? Plaintiff is absent. Defendant number 1 appeared in person.
My lord.
Few lines below, after hearing defendant number 1, I feel that personal appearance of plaintiff and defendant number 1 is necessary. Fix 9(3) for appearance of defendant. He was already there in the court. Why fix again for his again for him to appear? This person appears to be a little. On the next date, no appeared. Defendant present. Due to present situation, court cannot proceed. Then what happened? Court is adjourned. Parties absent. Parties present to counsel. He prays for. Okay, court is adjourned. Parties hence court adjourned. Okay, then parties are present. Adjourn. Fix Iman for appearance of the plaintiff. Then what happened? Case is endorsed to someone else. Plaintiff is present through counsel. Defendant number 3 represented by court. Remaining defendants are absent without steps. Peruse the record. Plaintiff was closed on 26/3/19. The case proceeded ex parte against defendant number 1, 2, 4, and 5 by this court order dated so and so. Hence, the defendant have produced their witnesses till date, or have not. They shall be given chance to produce their witness, if any. For defendant number 3 witness, and if any. Yes, after this case being transferred, after this case was transferred on 19/2/2021, there does not seem to be any intimation to the defendant number 1 that this case has been transferred to this court. Even in the case of an ex parte order, what happens? You don't file the written statement, but you can still cross-examine witnesses. Can you not?
And my lord,
so, when the defendant number 3 witness is being called, should he not have an intimation that yes, witnesses are coming, please come and cross, because the court has changed.
And
once the court changes,
yes,
should there be a notice?
My lord. And also, my lord, there are no order of the trial court that has been placed before this honorable court prior to 30/08/2016, because 2 summons was served on 2015 and on 28/06/2016. Now the orders reflecting that these 2 summonses were duly served and received by the appellant hearing has not been placed before this court.
What was the date for that COVID pandemic cutoff? When was it lifted? March 2022?
Yes.
Is it not?
Till 28th of February 2022.
22?
Yes.
No adverse orders could be passed. How
Yes.
can ex parte orders be passed against you?
But yes, my lord, the ex parte order was passed on 2019.
19.
That was prior to
2019,
the pandemic.
yes.
And also, my lord, while filing the CMA application before the trial court, the appellant herein had not made out that as to why he was prevented from appearing before the trial court prior to the ex parte order was passed. No sufficient cause was
Where
shown.
is that application?
The application starts from page
number
page 14.
14, 1-4.
1-4. I think we'll have to call for the trial court records because these orders, they are not inspiring confidence as of now.
And in the CMA, my lord,
Yes, what is the ground you gave?
Yes, my lord. I'll read out, my lord, if with your lordship's permission. Page 20, my lord. For the impugned judgment and order dated 13/12/2021 along with the order dated 23/1/2019 passed ex parte against the applicant is bad in law and the same is liable to be set aside by this honorable court. Number 2, for that the applicant had never employed the services of the OP number 1 in the contract work, that is construction of Kamala Nagar to Chotapan Suri Road, improvement and widening group number G. And the said contract work was awarded to the defendant number 3 who had authorized Ms. Sujata Chakma, wife of Buddha Lila, resident of
Just a
Kamala
minute, just
Nagar,
a minute,
Longkai
just a
district, Mizoram, to perform and execute the said contract work. By power of attorney dated 11/10/2010. In fact, the said Sujata Chakma had also received a check amounting to rupees 52 lakhs 1,364 from the concerned authorities for the said contract work, which can clearly be verified from the letter dated 30/3/2011 and check number D485675. Therefore, the claim of the OP number 1 against the applicant.
No, you tell us where have you written why you could not appear before 23/1/2019?
My lord,
where is that ground?
My lord, I have mentioned that in
none, my lord.
Paragraph number 3, page 17.
Huh?
Page 17, my lord, page 17, paragraph number 3. That during the proceedings of the said civil suit number 51/2014, the OP number 1 had submitted miscellaneous application number 338/2016 for taking
When did you
steps-
receive the notice for the first time?
I received notice for the first time on 2019. That was after the ex parte order was made.
And you did not move the court for?
I moved to the court, he was absent, and as we have written...
You did not move the court for setting aside of the ex parte order?
I didn't know about anything, my lord. I came to know only after the pronouncement of the judgment, because it was during pandemic when I appeared before the trial court.
But you went to the court?
I went to the court, and my lord, as we've read out the order, the court says the appearance of the plaintiff as well as the defendant number 1 is necessary. So I was sent back.
Even if it was necessary, without your application, can the ex parte order be set aside?
I have made an application, my lord.
For setting aside of the ex parte order?
Yes, my lord.
Where is it?
It is that I have read out, my lord. It is rejected.
Which one?
This one, page 17.
This is
my
after
lord.
the judgment.
This is after the judgment. Back then, my lord, as I was saying, my lord, back then it was during the COVID-19 pandemic. So I was not allowed to touch that anything. And court informed me that his presence is necessary. So I waited.
The courts
Then-
were not allowing you to do anything in the court, and yet they are calling everybody to the court.
Yes, but
How can that be?
Yes, he was upset, my lord. And I went back when it was fixed the next day. And he was again absent. And thereafter, there was a lockdown. And the court took up the case, adjourning the matter as per the direction of the government.
That is fine.
And
But
I was not...
ex parte having been done on 23/1/2019.
Yes.
And you received the first notice when?
on
The next time you were given the, this thing was on 2011 you
yes,
received it but you could not appear.
yes, my lord.
Then it was fixed for 18 to 2020.
Yes, my lord.
Is it not?
Yes, my lord. Because I merely appeared as your lordship
So
stated.
18 to 2020 there was no lockdown.
18 to 2020.
There was no lockdown.
There was no lockdown, my
Then
lord. I appeared.
And you said
18
that you
to
didn't get a
8
copy of the plan.
And the court says, after hearing defendant number 1, I feel that personal appearance of the plaintiff and defendant number 1 before this court is necessary. 9/3/2020, there was no lockdown. And I again appeared, my lord. Plaintiff is absent without cause. Defendant number 1 appeared in person. AGA are present. Case cannot be proceeded due to the absence of the plaintiff. Fixed 6/5/2020. Now there is a lockdown, my lord.
Now after 9/3 it is lockdown.
Yes.
But even when you appeared on 18/2, you did not thereafter
He is
move
an- he
any
is an
petition
engineer.
for setting
He
aside.
appeared in person and he is not aware of the implications of law.
Your duty to file a application for setting aside of the ex parte order.
Yes, my lord.
Where does that go?
I was due to file it back then, but due to my implications of the law, I had not filed, and there was a COVID-19 lockdown.
You
But-
were required to take a counsel
Yes,
to
my
file
lord,
it.
After I have taken a counsel, I had filed an application, the delay was condoned. The delay, everything was condoned by the trial court. However, the application was not allowed. My lord, I am not asking for saying that I should not be held liable or anything. I am just asking that I should be allowed to contest the case on merit, because I've been held liable for rupees 20 lakhs.
This TCR was called, scan copy, TCR scan copy was called, any point of time? We'll have to see that summon part. You are appearing for respondent number?
Number 1, my lord.
Number 1, and what happens to 2 and 2 to 6? They don't appear.
Represented, my lord.
My lord, I'm appearing on behalf of 2, 3, 5, and 6.
2, 3, 5, and 6.
Respondent number 4.
Number 4. Okay. You filed your affidavits? No. Yes or no? No objection to what? Okay. And your? And yours? You have any objection?
No, my lord. We are just a contractor. We are just awarded the contract, and it was executed by Sujata Chakma. And all the bills are also withdrawn by Sujata Chakma.
So, my lord,
It is between you two.
my lord, I have been held liable to pay for another man's contract work. That is so unfair, my lord. And just because it was an ex parte order, and my lord, if your lordship may kindly turn to...
Okay, take down. Take down. Heard Mr. So-and-so. But then this gap between 18 to 2020 and the imposition of the lockdown,
Yes, my lord.
you did nothing in between.
Because, my lord, I was advised to appear again along with him, along with the plaintiff, as he was absent. I did not engage any counsel.
It is not as if you are an illiterate man. You are the joining, junior engineer.
Junior engineer.
Ah,
Because, my lord,
that must prudency.
I trusted the trial judge saying that you do need to appear.
Who, the writer?
The trial court,
Trial court.
Trial
Okay.
court.
Okay, take down. I heard Mr. So-and-so and counsel appearing for the petitioner. Also heard Mr. So-and-so and counsel appearing for the respondent number 1 and Mr. So-and-so appearing for the respondent number 2, 3, 5 is gone. 5 expired.
Yes, expired, but substituted by his son.
Okay, 2, 3, 5 and 6, 2, 3, 5 and 6 and Mr. So-and-so and counsel appearing for the respondent number 4. Full stop. It has, next para. It has been submitted by the learned counsel appearing for the appellant that it was that he had received summons to appear before the trial court only sometime in the year 2019. And thereafter he had entered appearance on 18/2/2020. 18/2/2020 and 18/2/2020 and 9/3/2020. Full stop. On those dates, the plaintiff had not appeared before the court, and the matter was fixed on 6/5/2020. Full stop. Unfortunately, by that time, the COVID pandemic had set in and the lockdown protocols were enforced, and therefore he could not appear before the trial court on subsequent dates. Full stop. It has been further submitted that the case was transferred to the Court of Senior CJ-Roman 2 by order dated 19/2/2021, and thereafter the petitioner did not receive any further summons informing him about the change in the court, and therefore he could not put in appearance even after the protocol bans of COVID-19 were lifted. The learned counsel for the appellant has submitted that the appellant had never received notices or summons prior to November 2019, November/December 2019, and he also was unaware of the paper publication made to serve summons upon him. Full stop. Next paragraph. The learned counsel for the respondent number 1 has submitted that the trial court had directed the case to proceed ex parte against the appellant herein by order dated
23/01/2019.
2009 itself, comma, which is a date prior to the advent of the COVID pandemic, and therefore, unless the appellant, and therefore, since the appellant had failed to show cause for his non-appearance in the period prior to how much? 19/3/2021.
23/01/2019.
23/01/2021, comma, the trial court had directed the matter to proceed ex parte. He has submitted that the later on appearance of the appellant herein would not mitigate the reasons for the court to proceed ex parte against him by order dated 23/1/2021, 2019. Full stop. In view of the rival submissions being made before this court, comma, this court deems it appropriate to peruse the records of civil suit number 51 of 2014, which was then pending and which was disposed of by the court of the, where is that order? Where is that, this thing? Judgment decree, where is
My lord, this is at page number 102.
102, page number 102?
Yes.
By the court of the senior civil judge number 4, Aizawl Judicial District, comma, Aizawl, so as to peruse the orders passed, comma, summons issued, and other official records to determine if the appellant had enough reasons for his non-appearance in the title suit up to 18/2/2020. What you will bring on these certified copies, or we have to call for the records?
My lord, I can bring certified copies.
But then you'll need the certified copies of the summons sent,
My lord, the summon
the
is already here in
receipts.
It's already here, the certified copy. The summon that we have perused earlier, my lord.
No, those are 1 or 2 summons.
Page number 124,
There may be more,
125 and 126 are summons.
120,
124, 125 and 126.
124, 125 and 126 are the summon issued by the trial court. It's not a certified 2 copy, but my lord, these are the summons.
This case is disposed of. So, call for the TCR of civil suit number 51 of
2014.
2014. Yes, list this matter again in the in the 4th week of January.
My lord, if your lordship permits.
On receipt of the TCR, yes? What? Yes, tell us.
There is an execution matter pending before the trial court, wherein they have tried to attach my house and my vehicles, and even my pension salary. So the impugned order may be impugned order dated the 17/12/2024 may be stayed till the next court date, my lord.
My lord, that has
He is standing, otherwise he would have jumped up.
So during the pendency of this appeal, my
Since
lord.
we are considering it,
Yes.
However, my lord, that has not been.
no, since we are considering this matter, no adverse action against him.
Yes.
Till the next date.
Yes, my lord.
We will say status quo with regard to the execution case.
Yes, my lord.
Till the next date fix.
Till the
Yes.
next date.
It has been submitted by the learned counsel for the appellant that execution proceedings have been initiated against him, which also include attempts to
attach my house,
attach the house and
my
property
vehicles.
and other movable properties also. Full stop. Since this court is in session of the matter as to whether the appellant should be afforded an opportunity to contest the title suit, this court deems it fit in the interest of justice to keep the execution proceedings with regard to the judgment and order dated 13/11/2021 in abeyance until the next date of listing of this case. Full stop. Further orders would follow on receipt of the trial court records. Full stop. List this matter. Don't then you strike out that part in the last week. Ko strike out kar dijiye. Give us a date in January. I think we can take it up on 27th. January list we have. Fantastic. 27th of January is
Yes,
good
my
enough?
My
Or you want it before that?
My lord, if.
Listed on 20th of January, 20/01/2026, yes?
If your lordship could kindly indulge me
Mhm.
by recording my objection, my lord.
Oh, yes, yes. You see, it has been pointed out by Mr. So-and-so that execution proceedings have been initiated. Mr. So-and-so has vehemently objected to the prayer for keeping the execution proceedings in abeyance. Full stop. However, since this court is in session of the matter, it is only because of the session of the matter we are keeping. Once it is executed, what to do? Nothing will remain. Okay, thank you.